This conference will now be recorded.
Awesome, awesome. All right, well, thank you all for joining us this morning, everybody. My name is Chelsea McElvain. I know it says Jackie Longstaff. Like I said, we did a laptop switcheroo. I am a marketing assistant here at the Cromeans Law Firm, and we thank you so much for joining us this morning to talk about protecting your business as it grows in the construction industry. This morning, or this afternoon rather, we'll have our owner and managing partner, Carolyn Croming, speaking to you all, diving into the nitty-gritty about the subcontract, your rights as a contractor, and things that you need to know if you're going to be moving from residential into commercial or something of that variety. We just have a couple of things that I would like to go over before we get started this morning. First and foremost, if you could all mute your audio. I'll go through really quickly and make sure everything is squared away. And if you just stay muted until the end of the webinar this morning. If you have any questions throughout the presentation, just jot them down and you're more than welcome to either unmute yourself at the end, or if you'd rather, instead of writing them down, you can send them in the chat of the webinar as well. And I will be sure to make sure that they are asked before the presentation ends. We'll have a Q&A at the end of the presentation. And then additionally, I will be putting a little bit later on some information in the chat as well, as far as if you're interested in setting up a consultation, how we can start that process for you too. So if that is all, let's see here. All right, that's all I've got on my list this morning. So I'm going to go ahead and pass it over to Carolyn and we can get started this morning.
Hello guys, thank you for being here. I appreciate it. We're going to dive into all the things you need to watch out for as your business grows. And then if you're thinking about taking your business from residential to commercial, some of those things that you need to watch out for. All right, Chelsea, the first slide, please. All right, so most companies that are doing well in business already are always looking to scale and get bigger, whether that's from larger residential projects from large residential projects to commercial. So we're always looking, most companies are always looking to grow. And so there's some things that we need to watch out for while we're doing that. So some things you want to account for as you grow, either in residential or commercial. Subcontracts, hugely important. If you have subs working for you, that you have a contract, and we'll go over that here shortly. What insurance covers and what it doesn't, what type of insurance you need, and what are the ramifications of not having the proper insurance. Your rights as a contractor if you get sued as a residential contractor, and if you're going to sign your first commercial contract, some things that you should watch out for if you're new to commercial. All right, so having a contract as a residential contractor between you and your client is hugely important. And you need to have one that does the two most important things of a contract. So number one, you need to have a contract that manages expectations. I've been in the commercial and residential construction industry from the legal perspective for the last 17 years, and I've represented both homeowners and contractors in legal battles. And I can tell you that if in all of the situations, if the expectations had been managed better on the front end, the result of being in a lawsuit would not have happened. So really take some time and make sure your contract between you and the owner is in plain English and manages expectations, because a homeowner client absolutely has expectations. They're not based on anything in construction reality. It's based on what somebody told them, their brother-in-law or whatever, not on what's really going to happen. And if we don't manage those expectations, that's what we'll be judged against, right? And they're unrealistic. So have a clear contract that's in plain English. It manages those expectations. And then the second important part of a contract is that it's CYA, or it covers your ass if you end up getting into dispute. So having those two things in your contract with the owner is hugely important. So the next part, once you have that contract with the owner squared away and you feel comfortable with that, is a master subcontract agreement or some type of an agreement with your subcontractors. What I recommend is a master subcontract agreement, because the master part is like 10 or 12 pages and the subcontractor only signs it once. And so that deals with payment terms, insurance, making sure you're added as additionally insured, all of the important things, and they sign off on that once. And then for every project, you issue them a work order that says, okay, on this specific project, you're going to do this work, this schedule, and here's the payment terms, right? And so that they don't have to sign that master part once, it follows them, and then just a work order, for as long as they work for you. So, and another reason why it's very good, and we'll get into this here in a little bit when we touch on insurance, is that if you have a master subcontract, it is one of the key elements that we look to determine if somebody's actually an employee or a subcontractor, which the difference is hugely important in the legal ramification. One thing I like to point out here too is that, okay, the owner hired you to do work, and then you hired the subcontract to do that work. Once you sign that contract with the owner, you're on the hook to do the work. Whether the sub does a good job or not, it's all on you. The liability does not just pass through. So you would stand, if there's issues with the work that the sub does, the owner is going to come after you, not the sub. So just because you have somebody that subbed out to do the work does not relieve you of your obligation to your promise to the owner to do the work in a good workmanlike manner. Stick to the schedule, right? So we want to make sure that the sub is on the same timelines for schedule that we are. So we put that in the work order. That way, he's held responsible the same way you are. Because, if we don't hold him to that same schedule, the subs might not do the work in the same promise schedule that you did. So let's make sure we put that in the work order, and that they're aware that they got to follow the same schedule that you promised to the owner. So, like I said earlier, if you don't have a subcontract, it is easy. It's easier for somebody to try to classify a worker as an employee as opposed to a subcontractor. And so, what are some of the dangers of that happening? If a subcontractor is injured on the job, if they're an employee, technically it's you're responsible to make sure that you take care of them if they're injured. If they're a subcontractor, they're responsible for themselves. So that's one of the things that an important reason to have a subcontract. And then the other issue too is if we get into that scope and they're questioning whether it's an employee or a subcontractor, there is also could be a potential claim for taxes not being withheld and overtime not being paid if they could truly be classified as an employee. So having that master subcontract really makes that agreement look like what it is, and it's a subcontract agreement. Oh, I was going to say on this one, I have the other thing that it could do is if you have, like, say you have an internal office where you have employees and you have workers' comp for those employees, when your workers' comp insurance does an audit of your books, which they can do, and they see all of these checks written to these other individuals, if we don't have subcontract agreements with those individuals or other businesses, they could potentially say that they're employees and they should be covered on your workers' comp. And then you'll have, when they do that reconciliation, you'll get a huge bill at the end of the year. So having that subcontract agreement is very important for that relationship as well. I actually have litigation going on with a client now who had those subcontracts, and thank goodness we'll be able to save him. But if he didn't, they might be all categorized as employees, and he would have a huge insurance bill. So yet another reason why it's important to have a subcontract agreement. So one of the other things, yes, that we need to talk about as you scale and grow your business, and just in business in general, is what does insurance really cover? The first rule of thumb is insurance covers as little as possible, right? Insurance companies are in the business of accepting premiums and getting paid, not paying claims. So their main role in life is to figure out how not to cover a claim. So just know that going in, what happens a lot of the time is even if you're covered, you might get a denial letter. And a lot of people just drop off at that point and assume, oh, I'm screwed, I don't have any insurance. That's not the case. If you push back, you can get coverage. So just know if the first letter is the denial letter, come see your attorney, whoever that is, and let's really look at it. Can they get out of this or not? But a lot of the times they can shake a lot of claims loose just by doing an initial denial letter. So know that. Okay, so one of the big misconception out there is that only an insured can file on their insurance. Okay, so let's take this, give you an example like in a subcontractor world. So if you have ABC subcontractor working for you and they have insurance and you get a copy of their insurance, that's great. Something happens on the job and you need to file a claim on their insurance. If you are not added as additionally insured onto their insurance, they are the only one that can file a claim. So meaning that if something happened like, and there was, damage to the property and you wanted to file a claim on their insurance, you could not if you're not listed as additionally insured. You can sue the person who, the sub, ABC sub, and hope that they would turn it over to their insurance company and file their own claim, but you could not file the claim. So meaning that only the insured has the right to file a claim on the insurance. So what do? You need to make sure that you're added as additionally insured so that something like that does happen, your name is on that certificate, and then you can file a claim whether or not the insured wants you to file a claim or not. So whether or not ABC agrees with the fact that you should be filing a claim, you could still go ahead and do that. So very important to take care of on the front end. That's why you get listed as additionally insured. Another misconception is that insurance cover bad work. Insurance, generally as a rule, does not cover the defective work itself, but covers the damage as a result of the bad work. So I'm not sure what happened there. Maybe we have another laptop issue, but so for example, there we go. If someone, something was installed incorrectly on a roof and it caused leaking through into the attic, which soaked a bunch of stuff and caused a bunch of damage to whatever was in the attic. The insurance would cover the flooding, the results of the flooding, but it wouldn't cover fixing the roof. So that's important to know. Like, even if you get your subs insurance, if they do a shit job, the insurance is not going to cover the bad work itself. It's going to cover the result of the bad work, right? So something to be extremely aware of. And there's some insurance providers I can send you to, but as a general rule, you really can't get insurance to cover bad work. Workers' comp may or may not be required in your state. Texas does not require it, but there is a penalty if you don't have it. So you might as well have it. And what does that mean? Is that it compensates an injured worker, an employee, while if they're hurt on the job. It'll cover medical bills, lost time from being unable to work. And if you have an employee right now in Texas and you don't have workers' comp, you'd be liable for that, plus the penalty for not having workers' comp. But one of the benefits is that if you do have workers' comp, you can't be sued for the damages, lost work, medical expenses, things like that. So it is worth the investment. I know construction companies usually have to pay higher premiums because they have riskier jobs, but the workers' comp will classify the amount of employees you have out in the field versus your office employees. So that's all taken account for. But you need to stay on top of, make sure they're classifying everybody correctly. So I have several cases going on right now that are roofing contractors that hired subs, and one of the subs workers fell off the roof, and I have one that died, one that was injured, and my client who was hired by the owners and one being sued, right? And so they have general liability insurance, which doesn't cover subcontractors, so they're not getting any help from their insurance company, but they don't have a subcontract to prove that this is a subcontractor independent of themselves. So again, another important reason to have a subcontract, right? To push that liability off to the sub himself and be responsible for their own employees. And then if we had a subcontract, we could get out of the lawsuit. But we're not gonna be able to get out anytime soon, because there's a huge question: are we a subcontractor or are we an employee? We're unsure, and if we're You know, if the person's an employee, then my client's on the hook. And so it's a very expensive legal bill. So what I recommend is getting with an insurance expert that knows about the construction industry. There's several out there. I can give you a referral if you need one. Specifically construction and what you do and what your risks are. So you have the right type of insurance, and you could get insurance if you wanted to that's cover subcontractors. So something very important is, especially as you grow, you want to make sure that you have the right kind of insurance that covers you for all things, right? Okay, residential contractors and what happens if you get sued. What are your rights? How does it all work? Residential construction are different. Just generally speaking, there's a lot of protections in the residential world for homeowners and for contractors too, in most states anyway. So in commercial world, not so much. So there are some protections here. So the main thing that I can say is how not to get sued is to respond and resolve issues if you can, right? Ignoring them will definitely end up in getting you sued. So respond, and I have a whole nother, and respond in writing with an offer or some way, even if it's not everything that they want, but showing that you're trying to be reasonable to correct everything that they want. Another thing is make sure that your information with the Texas Secretary of State or the Secretary of State of wherever you're registered to do business is up to date. Because once you're sued, if they can serve you by serving the address in the Secretary of State, and you might not even get it, and then they can take a judgment against you because you failed to show up. So that the stuff you have on file with the Secretary of State is hugely important. Make sure it's up to date, because that's where legal notices will be sent, and they are considered received whether you receive them or not. So making sure that's all up to date will be great protection. So in most states, and especially in Texas, there is a process that has to be followed before a homeowner can sue a contractor for defective work. And in most states, this is the case. So if you're working in other states, you want to make sure we take a look and see if that's that's the case in the state that you're working. So, and if they don't follow this process, the process of getting you notice, which we're going to go over in a second, then you can stop the lawsuit until that process is done. So important to know. So like in Texas, this is what the process looks like, and in most states is that the homeowner has to send you an itemized list of all the work that they're claiming is defective or not done correctly. Once you receive this letter, you have a chance to go inspect if you want it. You don't have to, and go view everything that they're saying is wrong. And then you have after that point in time, you have a chance to make an offer of either cash, fixing it, or some combination thereof, to say, hey, and here's the thing, guys, is when we go through this process, they might not really have any claims, but will we give them something not to have to go through litigation? Absolutely. So these are things that we consider. If we can get out for a couple grand, it's probably a great decision as opposed to moving forward with litigation. So once you make that offer, if the homeowner refuses it, there's usually some type of penalty if it was a reasonable offer. So like in Texas, if you make a reasonable offer and it's rejected by the homeowner, if they go forward with litigation, they could not be able to recover their attorney's fees or anything larger than what you originally offered. So know the process. So like in Texas, you receive a demand letter with an itemized statement. You got 30 days to request an inspection, and then you have another 60 days to make an offer. So that whole process, and it's worth following that process, because it could really limit the owner's ability to recover against you if they don't accept a reasonable offer. Okay, so some of the things, if you're considering about going from residential to commercial or picking up your first commercial subcontract, some of the things that you should watch out for, right? Because it's a completely different ball game, whether you're residential or commercial. So if you're thinking of crossing over or trying a little bit on the commercial side, let's talk about some of the huge differences. So one of the huge differences on a commercial project, you're going to do a full bid. So like in a residential project, you kind of give an outline of work. This is going to be your scope. So you're going to do a full bid and estimate when you're doing this bid and you submit it, what I tell my clients, especially right now, is to put a material escalation clause in that proposal and that bid, and a date that it expires, so that you're not on the hook forever for the amount that you put out there. And if there's things that affect your price, like material escalation costs, that you can recover that. Because if you don't, then you won't be able to. Like you put a bid out there and it's accepted 6 months later and the prices have changed, it's on the contract from the legal perspective, you're not entitled to get the difference of that, the material change. So something to be wary of when you're going into the commercial world. The other part is we always want to do a itemized bid on the commercial side, meaning you're listing out all the work that you're going to do specifically, and then a price for that. Because if you do a turnkey, if you miss something, right, then you're on the hook to do whatever was ever in that plans and specs that you bid. And so it may end up costing more than what you bid. So hugely important, do an itemized bid on a commercial project. So your bid was accepted. What's next? Don't immediately sign the contract. Let's take a step and let's go through it. There is no uniformity in commercial subcontracts, just like there's no uniformity in residential contracts. In residential contracts, there are some languages that has to be in there, and every state has some. There is no protection like that on commercial contracts because you're considered to be, a savvy business person and know how to protect yourself. So these things are, there's no protections. There's no set of rules that protects you. So just know that you really need to take some time to have it reviewed and understand what's in the contract before you sign it. And then the next thing that is hugely different from residential is that what you bid does not actually become part of the contract. So you send out a bid, you get a contract back, and there's a scope of work attached to that contract, which may or may not be the same thing that you bid. And 99% of the time, it's at least a little different. So meaning that if you just, oh, I got a contract, I'm just going to sign it, I'm not going to review the scope, and the scope of work is different than what you bid, and you're now on the hook to do that additional work, whether it was included in your price or not. So we always review the scope as if we're bidding a new project and make sure those prices match. So if you say you get a contract back and you realize, hey, this is the scope does not match my bid, it's got additional work included, what should you do? You need to request that the contract be revised, because if you don't, then they're like, oh, we'll just do a change order and fix it later. No. What you sign will be used against you. So make sure that it's correct. If it's not correct, don't sign it. So say, hey, this scope of work is different. We need to add X, Y, Z and increase the price, send it back, and then I'll sign it, okay? So don't sign it unless it's correct. So, and another thing too about commercial contracts in general is that they should be negotiated, right? We should go through and we should make sure that everything is on board, and I'll let you know what the risks are. And if it's not a risk that you're willing to take, I don't think I have a specific slide on this, but all of these commercial contracts have pay when paid clauses, meaning if the GC doesn't get paid, then he doesn't have any obligation to pay you. And so knowing those type of risks when you go in, have it negotiated. Negotiate it, make sure the bid and scope are the same. Another thing that I like to point out if you're new to commercial is that when you sign a subcontract, it incorporates the terms of the contract between the owner and the general contractor. You may have never seen this contract, and you can agree to be bound by it even if you haven't seen it. So when I tell my contractors is, hey, get a copy of that contract or have it removed, right? Just so you know what's in there. Because like your contract might not have liquidated damages, but that contract might. And if it's incorporated, then now you're open to liquidated damages for not finishing on time, right? So huge thing, make sure that you get a copy of that contract. So we've already gone over lump sum price, but do an itemized list of everything that you're agreeing to do. You're hired to do your scope, not your bid. review the scope as if it were a new bid. So one of the smaller incidents that I've seen of this, which is the next slide, that represented a door contractor who was doing doors on a community college, and he was glass doors. And he sent over his bid. They sent over a contract. He just signed it. He installed the doors, and then he got a notice of defect letter from the general contractor saying, hey, you need to come finish or you'll be in default and I'm not going to pay you and I'll have to hire somebody else to finish your work. And what it was is that he was supposed to, he agreed in his scope of work to install the electrical components that make the doors work. He's like, so he came to me and was like, I didn't bid that. I was like, yeah, but what does your scope of work say? Of course it was in the scope and it was not in the bid, but it was in the scope. And so then he was on the hook to do the electrical work for the doors, even though he had not bid it. And in this case, it was a small amount of money, but I've had stories like this over and over again where the dollar amount is very large, hundreds of thousands of dollars. That's something that you didn't realize was different than your bid. So hugely important that we know the difference between bid and scope. So guys, that's kind of a quick overview, residential, commercial, all of the things. If you have specific questions, you can put them in the chat, unmute yourself. Yeah, it's a lot, but you know, it's worth scaling your business, especially if you know these things to watch out for in the front end.
Do we have any questions for Carolyn this morning? You're more than welcome to drop them in the chat, or if you'd rather, you can unmute yourself and ask them there as well.
I'll have a question.
Yes, ma'am.
Sure.
Is there any specific templates, like for commercial construction, there's like AIA. Is there any templates specific to residential that are preferred?
Not really, and especially like if we're doing brand new builds, there's like, I know that the GHBA has a pretty good one from the contractor perspective. So that's kind of the uniform one that I know of there. But if like residential repair remodel, there is not anything out there. And really, it so differs by state too, what has to be in there. But there's nothing that, I mean, Rocket Lawyer has one, but it's not very good. And we do them on a flat fee too, if you're looking for residential repair remodel ones, just because there's not anything out there that I've seen that's really good.
Did you say the GHAB or the NAHB?
No, the Greater Houston Builders Association.
Oh, okay.
They have one that's really good for if you're a new build, like you're building from the ground up.
Awesome. Thank you.
No worries. They have a really good one that's very contractor friendly. And then if you can get that, and that, I don't know how much they charge for it, but and then I can help with negotiations on it and make it more customized too.
We've got another question in the chat here from Eric. It says, is it possible to have a combo contract for residential versus commercial, or is it better to have two separate defined contracts?
So generally speaking, if we're talking about, so you're a residential contractor that wants to be hired by an owner of building to do a repaint, you can definitely use your residential contract for things like that. So, but when we're talking about, usually if you're going from residential and you're going into commercial as a subcontractor, they're going to have a contract they want you to sign. And that's when we need to worry about all those things that are in there. But if you're a residential contractor that's going to work for an owner that doesn't have a contract, your residential contract would generally work just fine because it's got the major terms. When you have to sign, if you're like doing a new build from the ground up, we're going to want a different contract than your residential contract. And then if you're signing a subcontract, then have it reviewed. But if you're, like I said, working for a building, an owner of a building and doing something, your residential contract would be more than enough.
Awesome. Hope that answers your question, Eric. All righty. Any other questions for Carolyn this afternoon?
I've got one more.
Sure.
Yes.
So, you mentioned having a master subcontract agreement. So is that are you saying that you should not make them sign a contract each time and then therefore just submit the work order each time? So kind of like a master services agreement.
Absolutely, just like that. And we do them on a flat fee. They're $2,500. So they sign like those general terms and conditions just once, but they apply to each project thereafter, forever in perpetuity. If they ever work for you again, they will be under that master subcontract agreement.
And then that would be, and that's also for like an individual who would be effectively, well, I guess everyone's 1099, right? But
Correct. And with that, just make sure that they're really a subcontractor and they work for other people too. And just because if they're, we don't want to, there's other ramifications if somebody's really an employee and we're treating them as a subcontractor.
okay, thank you.
No worries.
Awesome. Alrighty. One quick last call for questions. If anybody's got anything to ask Carolyn. And if you don't have anything right now, but something comes to you later, we'll be sending you Carolyn's contact information in the follow-up email, as well as a copy of this presentation for personal reference and use. All right. If we don't have any more, we'll go ahead and call it here. Thank you so much for joining us, everyone. We hope you were able to glean some excellent information, some super helpful stuff. And we'll be following up with you with a copy of the presentation, some contact information, and some other details as well. Thanks so much for joining us, and we hope you have a great day.
Bye. Thank you.
Bye.